I'm Jim Collison. We're live. We're back live Wednesday afternoon, Infotech 2014. And we've got a whole slate of interviews ahead for you, so hang around for the afternoon if you're out there watching live. Want to spend a little bit of time getting to know you guys. It's easier just to have you introduce yourselves than for me to stumble through it. So, Jeff, why don't we start with you? Tell us who you are, what you do, maybe a little bit about the company and the process.
Okay, my name is Jeff Andersen, and I'm a licensed patent attorney, and I practice at Baird Holm LLP. And I've been a patent attorney for 10 plus years here in Omaha. And as of 6 months ago, I started at Baird Holm because Baird Holm was interested in starting a patent practice.
Very, very cool.
And
that's a big, lately, right, especially with technology patents, that's become a very visible item, right, in that world. A lot of patent stuff going on. So,
absolutely.
Yeah, very good. Okay, welcome.
Thank you.
Come on.
My name is Kamaal Patterson. I also practice at Baird Holm, and I'm a patent attorney as well. I grew up in Omaha, Nebraska, and went to Creighton University School of Law. Graduated this past May, and really enjoying my time over at Baird Holm.
Oh, very cool. Yeah, and Jeff, are you from Omaha as well?
I am. I'm a Creighton Law School graduate also.
Are you a Creighton?
I am not a Creighton grad. I am a Nebraska grad, and
good.
I also graduated in 2013, same as Kamaal, and have been enjoying my 7 months at Baird Holm, and I'm originally from Alaska, so not the Omaha area.
Okay, well, the weather up there isn't that much different than down here, right? Cold and snowy.
Unfortunately, not this year.
Yeah.
So.
Probably a little colder here in Omaha this year than it was up in some parts of Alaska.
Yes.
Yeah.
All my friends back home called me to brag about the weather being nicer up there at times.
It just all moved down here to the Midwest.
Yeah.
It's not always that bad, right? It was particularly bad this year. Jeff, let's start with you. Let's talk a little bit about the session that you led here. We led off a little bit that the idea of patents has gotten a lot of attention, especially in the tech space of late. And so, what did you guys talk about?
What I talked about was just kind of giving the audience a couple of options for protecting their intellectual property. I discussed patents and trade secret protection, and what the requirements were for each, what the advantages and disadvantages of each mode of protection were, and just tried to use some examples that kind of hit home with them.
So if I'm a technologist today and I'm either writing a piece of software or I'm creating something new, can you give me a couple practical things that I kind of need to start thinking about in advance to protect what I'm and by the way, in the tech space, patents have gotten a bad name lately, right? It's one of those kinds of things where it's like patents is slowing down innovation, not speeding it up. So not to blame that on you guys, but you are patent lawyers. So any practical tips? And I'll throw that to you guys, but Jeff, we'll start with you. Any practical tips people should be thinking about with their technology?
I would say you try to limit the exposure of the technology to as few people as possible in the early stages, and to get a patent professional like ourselves on board early in the process.
So if you think you've got something good, get one of you guys early, right? Is that what you're saying?
Absolutely.
Yeah. Ari?
Well, and I kind of talked about today a little bit freedom to operate searches, which is when you're developing a new product or idea, you want to go out and kind of get a view of the landscape of what other technologies are out there, so you don't end up with a cease and desist letter in your mailbox. And then also, you mentioned patents getting a bad name, and so we have the whole patent troll problem going on right now, and there's a lot of argument that all stems from the issuance of these bad patents from the patent office, and there's some legislation going on right now at a national level, and some states are getting involved. So we'll see where that goes.
So as a developer, an inventor, whatever, if I go on Google and try and find that, I've started a few with the blogging and podcasting that I do. Maybe I wanted to start a new podcast, and so I did a Google search and I looked for the names. If I don't find it, is that good enough, or are there other things I need to do to make sure that I'm not using somebody else's trademark or patent?
There's certainly more in-depth analysis and searches that you can complete. Using Google is a good first step, but there are professional firms that will go even further and find resources that are pretty difficult to find through journals, technical bulletins, searching outside the United States to see what other art exists in foreign countries. It's a pretty complicated process, so depending on the idea, that will sort of determine how deep you need to go on the search side.
So is that what you guys do as patent attorneys? Is that kind of the research and looking into see, or do you have sources that you use to find those maybe where it's being used somewhere else?
Where we come into play is that we've worked with patent search companies that basically will submit to them the invention idea, and then they'll search for it, and we'll specify where we want them to search and what we want them to search, and then we analyze the results and counsel the client as to, based on the search, this is what, in our analysis, this is what it looks like.
And like a title company, do you guys take any liability if say you start SkyDrive and there's another company? Are you held liable for that if something happens, or how does that work?
Well, the one thing with any search, it's never 100% because there's always a group of patent applications that are kept confidential.
I gotcha. Okay.
And usually that is because anything that's been filed within the last year and a half is not accessible to the public, and it's not accessible via a patent search.
And for those reasons of someone trying to steal it, is that?
It's just a protective phase that the Patent Office puts in place between the day you file and the day that they publish your application for the world to see. They give you sort of an 18-month window where they keep things
and that's a good
wraps.
Thing, right? That's a good thing for the inventor.
Because when you file, sometimes you're looking to find a buyer for the technology. You can say it's patent pending, and you're trying to find a market to see, can I make a sale of this before prosecution and the patent application has sort of gone through to completion.
Yeah. So that's what patent pending means then, right? That I'm in that 18-month window?
Patent pending. Patent pending means that you filed some sort of a patent application and it hasn't issued as a patent yet.
Okay.
So it can be any time from filing to issuance, which can take 2 to 3 years on average.
Okay. It's a long process, right?
Very long.
Yeah, and it's fairly difficult. And is it getting easier or more complex in the system? And let me ask you this: is the Patent Office doing anything to change the way they do it these days?
I'm going to speak up because I was a former patent examiner. When I left college, I worked as a patent examiner at the Patent Office, and they're certainly doing the best they can to work through the applications that have been submitted and reduce the backlog that exists. But each technology is complex, and it's tough to go out and find what is the art that existed before you submitted your application. So it takes some time. I think to speak on their defense, they do a pretty good job, and I think we're continuing to make steps forward to speed up the process.
But there are things going on to make it better. I think sometimes we think, the government's doing, or is the Patent Office, is that a government?
Yes, it is part of the U.S. Department of Commerce.
Okay.
It's an agency.
It's the only government office that makes a profit.
Yes.
Oh,
yeah.
Really? So how much does it cost to submit a patent then? If I was going to submit that, what would be to the government? And then I assume if I'm going to use a patent lawyer, I'm not asking for your fees, by the way. No, I mean more along the lines of what am I going to pay the government because they're making a profit.
Sure.
Usually if you're going to pay just to get patent pending and to be, there's 2 types of applications. You can file a provisional, which lasts for 1 year, and it gives you a 1-year window to determine. It allows you to test the market before deciding whether you want to invest in the regular non-provisional application.
Okay.
So that's one fee, and then the non-provisional would be another fee. Generally, if we're talking about a small entity, a provisional is going to cost you about, for government fees, it's going to cost $130.
Oh, not terribly expensive.
But for non-provisional, it's more like $1,100.
Okay.
Nari, do you want to talk about the different types of patents that there are?
Oh, you mean utility patents? So
that'd be great.
Yeah, you can get the most common type of patents are utility, and those are for machines, processes, articles of composition and manufacture, things like that. And then there's also plant patents, and that is for plants, obviously,
seeds and the like.
New lines of crops that are being developed.
Right,
And then
because they mess with the DNA inside.
They do. And it's very interesting. They have to be asexual plants, and there's some specific criteria for that. And then there's also design patents, which are just you can patent an ornamental design, and a requirement of it is that it can't have a function. You just get a patent on the shape of the Coca-Cola bottle, for example.
Completely aesthetic.
Yeah.
Wow. Yeah, it's amazing. So you guys see this day in and day out, but from the outside looking in, sometimes it's like, I always think, is there really that much original content being created today that hasn't already been done? I mean, I would think just about everything's been done, but obviously not, right? I mean, thousands of patents are being filed every day, maybe?
Absolutely, and then there are thousands that are being issued each year. And the trend is just going to continue to increase because there are a lot of people in the world coming up with great new ideas to run a business or to improve their daily lives.
And you can still get a patent on an improvement of an already existing idea.
Yep.
If you come up with a new enough concept, you can still patent that.
And who makes that determination, right? Who sits there and says, yay and no, or yay and yay, right? On that, how do they do that?
The patent examiners, and it's a back and
Which
forth.
is what you did,
Yes.
right?
I was one of them. Yeah.
Yeah, it's a back and forth between the patent office and the patent attorneys. You know, we'll argue, well, the invention should be this scope and it's new for these reasons, and the
Okay.
patent examiner will push back and say, well, what about this? I don't think this is new. And ultimately, they have the final say in what's issued and what's not.
Is there a ratio of accepted to not accepted that they did not accept more than they accept, or how does that work?
It fluctuates from year to year. I think the last statistics I saw, about 2/3 or maybe closer to 70% of applications will issue as a patent. So that's a pretty high rate, but it's dropped below that in the past, and it's been higher than that in the past as well.
Okay. So it's not a static number, like it's like, oh, after a while it averages out to something, but fluctuates kind of based on innovation.
Yeah.
Jeff, you've been doing this a long time.
Right.
Have you seen sweeping changes in the last 10 years, or has it been pretty consistent just in what's going on in the industry?
Well, in terms of allowances, I think it used to be a lot more difficult to get a patent. I've seen years where the statistics were 40%. As far as changes, I think
40% would be pretty low.
Yeah.
Okay. Okay.
as far as changes, I think there's just more demands placed on patent attorneys to have a higher quality product. And, it's become more and more difficult to.
They've upped the game for you guys?
Yeah.
Is
And
that?
another huge change was, I think it's 2010 or 11, the American Invents Act changed the United States to a first-to-file country.
Which means what?
Which means there is a premium on getting your idea to the door of the patent office faster. And so big companies like IBM, Apple, Google, they already have a system in place to get disclosures from their inventors and get applications to the patent office. For smaller companies, individual inventors in their garages, it's been tough. And so that's why we talk about this difference between a provisional patent and a non-provisional patent. And it's been a big emphasis in our early goings at Fairhome, helping people with that process.
And it used to be that if you could show evidence that let's say you went to file a patent application and you found out somebody filed ahead of you, but you invented it before they did, you used to be able to show evidence and submit affidavits to get ahead of them. But you can't do that now. Now
They
it's
just said
who filed
it's when
it.
you file it, right? Did they simplify that for themselves because they didn't want to do the additional research, or?
Well, most of the rest of the world tends to follow more closely with the new system, and I
Okay.
think that's what they were trying to do.
Us standardizing on the rest of the world
Exactly.
Yeah.
on that kind of system. So big companies like you mentioned, Microsoft, IBM, the Googles of the world, they must have machines inside their organization that help them generate these patents. I would assume, right? They have lawyers. They probably have their own patent attorneys that do things like this.
In-house counsel and that sort of thing, yeah.
Are you guys do you guys help with the more patents, or are you helping on large scale as well? Jeff?
In my experience, I've had a mixture of both types of clients. I've done some work in the past for IBM, and what they would do is they'd have a committee that would go through all their innovations and rank them on a scale of likelihood that they should pursue this as a patent. That they know the state of the art.
Okay.
So they would rate inventions, and then they had in-house counsel, but there wasn't enough in-house counsel to handle all of their needs, so they would
They would outsource
some of it.
it.
Yeah.
Same
Yeah, that's in terms of what I saw at the patent office when I was an examiner. Most of the time, companies and individuals hire outside counsel, attorneys like us. Very few places will rely solely on their in-house counsel.
Okay, just because it's such a niche or it's difficult to they're going to rely on the experience of, because you guys are in those trenches every day then doing that.
I think that it's just a difference between the type of attorney. So an in-house attorney traditionally is sort of focused on managing the cost of whatever legal fees and litigation fees come to the business. And then attorneys like us sort of specialize in getting patent applications to the USPTO, helping you license your technology, defending it in court.
Okay. So let me ask you this. If I'm an inventor, and this is, I'm asking for your opinion on this question, okay? If I'm an inventor and I have a good idea, are my odds better if I go at it on my own, or are my odds better if I go with an organization, if I try to get, work for a larger organization like a Google or what have it, and get it done that way through them? What's been your experience, Ari? What's been your experience?
I'd say it just depends in that context on what kind of agreement you would have in place with any kind of
True, because that would matter too, right?
Yeah.
That organization might want to keep.
Yeah, it depends who would own the technology or what kind of royalty you could get from it. So that's a kind of a tough one.
Well, do you guys, and Cox Communications is giving away. Somebody just won an iPad.
Oh, wow.
I think it's, yeah. So I think, let's see, we'll see if they, yeah, there it goes. There's the iPad.
Wow.
I should have tried that earlier. I passed up my chance.
That's the most noise I've heard from them the whole time.
Only they were cheering for us.
Yeah, I know, they are. Just bask in it. When we're done at the end, I'll tell them we're done, and then they can. Yeah. I'm sure they'll clap for us. Are there companies that are more friendly then? Let me ask you that you know of. Maybe that are more friendly to inventors than others, or in your experience, or is it just kind of a mixed bag? I mean, I'm thinking from an inventor standpoint.
I think it just sort of depends. The friendliness you're talking about is dependent on what kind of business a company is running. So a place like Google puts a high emphasis on their R&D and getting out these new innovative products. There are other companies that focus more on just providing services and licensing the technologies they need to provide those services. So they don't do R&D. They're not going to need inventors as much.
Right. Okay. Let's just do one more segment where we talk about the future a little bit. I always like that. I'm not asking you to predict it along those lines, but you're in the business. Like we mentioned at the start, the whole patent idea has not been well talked about. What do you see for the future of patents? Are there changes coming? Will it move just slowly as it's been moving, or are there changes coming that you see? Ari, we'll start with you.
I think that we'll see a lot of the inner workings of the American Invents Act play out in the patent troll context, with the fact that there were a couple new mechanisms implemented to challenge patents post-issuance, to invalidate them and give people a little bit more room to operate with some technologies. And so I think one of the bigger things we'll see is how well those mechanisms work.
Okay.
And I think along those same lines, Ari referenced some legislation working its way through Congress now, where I think the American people and then our congressmen and women are sort of outraged at the idea of patent owners going after mom and pop shops, saying you're infringing this broad-based technology that maybe shouldn't have been patented in the first place. And so I think we're going to see a change to block and prevent that sort of thing from happening, because it's created such problems and sort of.
And I have a specific example. So I'll follow that up. But Jeff, anything future-wise?
And I know too, right now there's some litigation that is going to redefine the role that software plays in the IP landscape, and that's been debated over the last 40 years, but and it's always changing, and so it's important to stay plugged in as patent attorneys to what level of detail we need to provide in applications to help inventors. So we take it seriously to stay on top of that.
Sure. Well, let me ask you this one specific, and it has specifically with podcasting. So I podcast I have both my own hobby in podcasting, and now I'm podcasting for Gallup. and that we just use that word because that's really, what most people know it as. That's come under fire. There's an organization out there right now that is trying to say they patented that idea, and so that's kind of tied up in this legal process. Any thoughts on that, just from a legal standpoint? I'm not asking you to make a decision on it or any of those kind of things.
Well, I know exactly what you're talking about. I listened to Planet Money on NPR, and they had a podcast talking about this specific individual who's been asserting that he came up with the podcast and invented it back in the 90s.
Right.
I think things like that are going to slowly start tapering down because there is this backlash to say enough is enough. That's not what you've patented. You can't stop other people from doing these basic things. So I think that's my sort of
I think we might see some of those patents get invalidated in either through these new mechanisms or in the court system, and the court will basically void their patent, and then
so that's how that would work. And we'll all these podcasters will. But that could take years.
It can, and it's expensive as well to go through that litigation. So.
Right. Well, and I know some of the podcasters who are making more money are pooling together to help kind of fight that, to say, hey, wait a minute, this is kind of for everybody. We've branded ours webcasts as opposed to podcasts from a work perspective, just to I wanted to kind of separate from that. I'm not sure in court that would matter. I don't know if
it's a step you took. Whether it would give any sort of substantive help, that's another story.
Yeah, Jeff.
And that's what I was kind of alluding to earlier when we talked about how the America Invents Act has upped the game for patent attorneys, because there are so many review processes in place now, like Ari was saying, to invalidate patents that just aren't that good. And so you really have to stay on top of it and create a high quality product.
So that's good, right? And the fact that there's new measures being put in place that should slow that piece down, so that we don't have these kind of battles 10 or 15 or 20 years from now. Because it takes what's a slow-moving engine, right? To get these things going. So you guys will be well employed for a long time. Well, guys, thanks for taking a few minutes. Very interesting conversation, and I'm glad that you took a few minutes to be with us. Thank you.
So much.
Appreciate it. You bet.